Welcome to Literary and Jury Charge Practice. Let's get started. Ready? As a court reporter, you need to know that the starting point for all laws in the United States is the Constitution. The Constitution is a written document that is designed to provide the basic framework for legal systems. A law is simply a rule of conduct. It defines what people must do in certain circumstances and what penalty or punishment applies when the rules are broken. No law can be contrary to what the Constitution mandates. Such a law would be unconstitutional and of no force or effect. You also need to know that the Constitution is not self-executing. It will not help anyone unless he or she knows how to use it correctly. An attorney's job is to put the Constitution to work for the individual. The court reporter's job is to provide an accurate transcript of court and deposition proceedings. You need to know that each state has its own constitution. A state's constitution is the source of fundamental rights within the state. No provision in the state's constitution can be contrary to the Constitution of the United States. In other words, the Constitution is the supreme law of the land. When you think of laws, you probably think about the second type of law called a statute. A statute is enacted by the legislative branch of the United States or a particular state. Statutes are part of the law that regulates your life. Cities and counties pass ordinances and codes which are similar to statutes. Governmental agencies often have the authority given them by the legislative bodies that created the agencies. Another type of law is common law, the law of English customs that the colonists brought with them to America. Common law has its origins from early English history. A civil wrong is a wrong committed by one person against another in which one person may be entitled to damages. An example might be that a person was injured in an automobile accident. When this happens, the person hires an attorney. If the person decides to, he or she can act as his or her own attorney, but it is not always a good idea to do so. The person has a time limit in which to file the case. The time limit is called the Statute of Limitations. Let's finish up this literary that we started before called Getting Motivated. Ready? Respect from others. The court reporting and captioning field is well respected. People are fascinated by the job and will inquire about the details of what you do. certified shorthand reporter, registered professional reporter, and all of the other specialty certifications reporters can acquire take tremendous effort and skill to attain, which makes the reporting field a unique and respected niche. Self-respect. Your desire to improve your life and achieve your goal can help to bolster your self-esteem and self-respect. A worthy achievement is a source of pride. Making up your mind. Review often the reasons that have made you decide to pursue this career, and add to those reasons whenever you can. When you fully understand this profession and what it takes to succeed in school, and when you have truly made up your mind that this is what you want to become a court reporter or a captioner, you have already taken some very crucial steps towards reaching your goal. Hard work, perseverance, self-discipline, and motivation can then follow. All right. Ready? Let's finish up with this jury charge. Here we go. Every civil case and every criminal case is subject to this time limit except one type of case. The exception is a murder case. If you do not file a case within the prescribed time, you lose the right to sue the other person. The time you have to file a lawsuit depends upon the nature of the case. When a lawsuit is filed on behalf of a minor, the attorney must have a court order naming the parent or someone filing the suit on behalf of the minor as a guardian during the lawsuit. The first step in every lawsuit is the filing of a complaint in court. The complaint is called just that, a complaint. The person filing the complaint is called the plaintiff. The person against whom the complaint is filed is called the defendant. The complaint sets forth the reason why the plaintiff feels the defendant has wronged him or her. It sets forth the legal grounds for the suit. In other words, it sets forth the reason or cause of action. Some various causes of action are as follows: breach of contract, divorce, or negligence. In a breach of contract action, the attorney would allege in the complaint that the plaintiff has a contract. Similarly, if you say one thing at the deposition but another at the trial, your veracity will be questioned at the trial. Unless you can explain the discrepancy to the satisfaction of the jury. The jury may find it hard to believe anything you say because of this. You should answer deposition questions with as much care and thought as if you were sitting before a jury at a trial. The discovery stage of a trial is crucial in preventing either side from being unduly surprised by the other at the trial. It is designed to provide a fair and faster trial. Unfortunately, some lawyers have gotten into the habit of using the discovery process as a means for harassing the other side. All right, let's start this literary, and it is called How Important Is Punctuation? Ready? Punctuation is extremely important. Without it, sentences cannot be understood. The job of a reporter is basically twofold: to capture all of the spoken words and then to transcribe those words correctly using correct and understandable punctuation. Yes, I know that it takes a bit longer to think about the words and how they should be properly punctuated. But isn't that what reporters are being paid to do? To capture words and to put them in a form that others can readily understand? I was a reporter for 39 years before I had to retire because of hearing problems that could not be remedied. During those years, I frequently worked with other reporters and had many opportunities to view their work. By and large, their work was satisfactory, but I confess that some reporters, even though they had fine reputations, did not transcribe with the proper amount of correct punctuation. Pushing the work out too quickly and without following the rules of punctuation is not professional. Court reporting is a profession, and it must be treated as such. If we want to receive the trust and respect of judges, attorneys, and, in fact, everyone, then we must do the best possible job of taking down all the words and transcribing them for any reader to fully understand. Yes, I know that many speakers do not finish their sentences, and that is exactly where our special knowledge of punctuational rules will come into play. If a speaker doesn't finish a sentence, or if he or she is interrupted or simply trails off, the only way to transcribe that is by a dash or 2 hyphens. Using a few periods to show that is incorrect. Why? Because 3 or 4 periods is strictly reserved for ellipsis. Ellipsis must be employed when one is quoting and deliberately leaves some words out. If those omitted words come at the beginning or middle of the quote, then 3 periods must be used to show that there was a deliberate omission. If the omitted words come at the end of the quote, then 4 periods must be used to show that there were words omitted at the end of the quote, that is, 3 plus 1 for the sentence ending, period. All right, we're going to have a real grammar or punctuation lesson, it sounds like. Let's get started with some jury charge material, a new jury charge here, and the title of this jury charge is Evaluating Testimony. Ready? Ladies and gentlemen, upon the issues here joined, the burden rests upon the plaintiff of proving all the material allegations of the complaint by a fair preponderance of the evidence. By preponderance of evidence is meant the greater weight of the evidence, the greater force with which the evidence on one side or the other appeals to your minds. But if the party having the burden in this case has satisfied you of the truth of his or her contention in that regard, he or she has sustained such issue by a fair preponderance of the evidence. If the evidence is evenly balanced for and against any particular fact in issue, then your finding upon such fact should be against the party having the burden of proof in that regard, since he or she has failed to prove the same by a fair preponderance of the evidence. If you believe from the evidence that any witness has testified falsely, intending thereby to deceive or mislead you as to any material fact or facts in the case, then you have a right to disbelieve the testimony of such witness, except insofar as such testimony is corroborated by other credible testimony. So some words to practice. We had corroborated, preponderance, all right, we'll finish that jury charge up in a bit. Now let's get back to our literary material. How important is punctuation? Unfortunately, some court reporting programs are incorrectly instructing reporting students to put in a series of periods to denote an interruption or a trailing off. That is incorrect. And some programs are instructing students that it is proper to have just one space between sentences. That too is incorrect. 2 spaces should be used after a sentence is finished, after an end of sentence question mark, and after a colon. And, of course, all words should be spelled correctly. Names, especially of the principals, must be spelled correctly. What I am attempting to do now in writing this article is to encourage and motivate every reporter, whether whether a student or veteran, to do the absolute best that he or she can in taking down words and transcribing them with correct punctuation. Semicolons should only be used if the reporter knows exactly how to use them. There are only 3 ways to employ them. 1. Between 2 independent clauses, sentences, as he is tall, she is short. 2. When transcribing series, as I told her that she was smart, that she was organized, and that she had a great future. And 3. To avoid confusion, as Ted came from Rome, Bill came from Berlin, Joe came from Arlington, Texas, and Harry came from Cairo. An error that I see frequently in magazines, books, and even the writings of some top reporters is the improper use of a hyphen after an adverb which precedes an adjective. The following sentence is punctuationally correct. The extremely tall girl is only 12 years old. The error that I see often in a sentence of that type is the insertion of a hyphen after, in this case, extremely. All right, that will conclude our literary and jury charge practice.